Hello and welcome to Williams Mullen Trending Now, an IP podcast, a legal podcast focused on providing innovative companies and investors with important and timely information concerning intangible assets such as patents, trademarks, copyrights, and trade secrets. My name is Ed White and I'll be your host today. Today I'll be joined by my colleague John McInnis, a member of our litigation practice group and a member of our NCAA Name, Image, and Likeness team here at Williams Mullen, to provide an update on the continuing implementation and evolution of the NCAA Name, Image, and Likeness policy. John, how are you doing today?
I'm doing great, Ed. Thanks so much for having me on what I understand to be the 50th episode. I am so excited to talk to you about NIL today. It is a timely topic with significant changes in the past few years and definitely something listeners will hear more from us on.
Yeah, I'm very excited about this topic today. And I'm also excited that it's our 50th podcast. So thanks for pointing that out. You and I will have to do our best to make sure we're putting forth a good product for our 50th. Well, in our past podcasts, we've discussed the House settlement, but we've had some additional information on how the House settlement is working out for collegiate athletes, universities, and colleges, as well as collectives. So that's what we're going to get into today, and I'm very excited about that. John, perhaps it would be helpful to remind our listeners how the House settlement came to pass. Could you give us the background on that?
Sure, Ed. The House case was brought by former and current NCAA athletes. They allege that the NCAA's former restrictions on allowing athletes to profit from their own name, image, and likeness violated antitrust law. The House settlement will provide back damages to the tune of approximately $2.8 billion across all D1 athletes who participated between 2016 and 2024 to be paid over 10 years at approximately $280 million annually. An estimated 95% of that will be paid to football and men's and women's basketball players. Institutions will also now be able to provide significant financial payments to athletes beyond those previously permitted. These include direct payments for the use of the athlete's name, image, and likeness, and additional payments for benefits commonly referred to as athlete revenue sharing. These payments will have an initial cap of $20.5 million per institution for the 2025-2026 academic year.
Thanks, John. Yeah, this is a real game changer. And I know that our team, our NIL team here at Williams Mullen, is already starting to see the effect of this with various colleges and universities and how they're working their NIL deals as opposed to how they were working with their collectives prior to this. Could you provide your thoughts on how you see NIL deals working in the post-House world?
Yeah, a key provision of the House settlement is that NIL deals will now be scrutinized by a third-party clearinghouse that will be managed by Deloitte. This third-party clearinghouse will be analyzing deals to make sure there is legitimate business value behind the deals and that the deals are not just pay for play.
So, John, will the clearinghouse procedure apply to all NIL deals?
And it's going to apply to all deals in excess of $600. So the threshold is pretty low. So any deal that exceeds that $600 mark is going to be scrutinized by the clearinghouse to make sure there's legitimate marketing value.
I see. And what do athletes do if their proposed NIL deal is struck down by the clearinghouse?
Athletes will have the right to appeal the clearinghouse's decision. That appeal will take the form of mandatory binding arbitration.
I see. And what occurs if a deal does not comply? I mean, are there penalties for non-compliant deals?
There could be penalties for non-compliant deals. An athlete who enters into a non-compliant NIL deal could face sanctions by the NCAA. So beyond simply finding whether the NIL deal was or was not compliant, a neutral arbitrator may also be tasked with deciding whether to uphold the NCAA sanctions levied against the athlete. Of course, if an arbitrator upholds the finding that an NCAA athlete has violated the rule, the athlete could then face punishment, including suspension or loss of eligibility. All that to say, the stakes are extremely high here, and athletes should be very wary of blindly entering into any NIL deal.
Yeah, absolutely. And as you know, our clients range from universities and colleges to athletes to collectives. So I think we're in good shape to consider this going forward. So, John, beyond the House settlement, are there any other emerging topics that will affect NIL deals moving forward?
Yeah, another emerging topic is the ongoing saga between Madden Yamaleava and the Arkansas collective, the Arkansas Edge. Madden, the younger brother of Nico Yamaleava, signed an NIL deal worth around $500,000. The NIL deal contained a buyout provision, which would require Madden to pay the school 50% of any remaining value on the contract if he left before the 1 year mark. Now, Arkansas Edge is looking to cash in on that buyout. Without getting too far into the weeds, one of the possible defenses at Madden's disposal is that the buyout provision is in tension with the state's NIL law. So this case is worth monitoring for a few different reasons. Beyond just the outcome, it will be interesting to see how courts and legislatures around the country react to lawsuits like this one, in which the collective is seeking to enforce a buyout against a player. If an Arkansas court does find that the buyout provision offends state law, I'm going to be curious to see if any state legislatures react to that holding. So far, states have been in competition to see who can make their state's NIL laws the most favorable to athletes, as an attempt to give their in-state institutions a recruiting advantage. As an example, on May 9th, very recently, Arkansas's state legislature decided to exempt NIL compensation from state income tax. It will be interesting to see whether penalizing athletes who jump into the transfer portal will be something that state legislatures avoid, ignore, or embrace.
Yeah, that's absolutely what we're seeing with regard to state legislatures doing different things, some passing laws, some taking no action. But nevertheless, with this changing landscape, how important is it to have legal representation involved in your NIL contract?
And it is absolutely critical. Whether you're an athlete, a collective, or just a business interested in securing your favorite athlete's endorsement, having legal representation at the outset of an NIL contract is really important. It's really important because the stakes are so high. You're going to need a lawyer to help negotiate the deal, draft the contract. You're going to need a lawyer that ensures the deal is properly submitted to the clearinghouse. And if push comes to shove, you are going to need a lawyer or a law firm that is comfortable representing you in arbitration. Anyone that is involved in the NIL space in a post-house world will need the help of a lawyer who is familiar with this budding area. There are a lot of competent lawyers out there, but the rules change so quickly in this space that it is extremely important that you get a lawyer that is familiar with all of the different moving parts. It would be extremely difficult for someone to get caught up to speed if this is not really part of their practice. The rules may have changed by the time we post this podcast, in fact. So you should really look for a lawyer that devotes at least some of his or her time to keeping at the cutting edge of NIL policy.
Absolutely. That makes perfect sense. And again, it's the NIL policy on behalf of the individual athlete. It's the NIL policy on behalf of those, colleges and universities. And to some extent, and we'll see where this goes, to the extent collectives are still involved, they need representation as well. So those are all excellent points. I really appreciate this time, John. This has been very interesting. This will wrap up our NCAA name, image, likeness update. Thank you for joining me today to discuss this topic on Trending Now, an IP podcast. If you have any questions or suggestions for future episodes, please contact us. You can also visit our intellectual property practice page at williamsmullen.com/IP. There you can find out more about our team as well as our past episodes of this podcast and legal alerts. Be sure to subscribe to this podcast to be notified when our next episode posts. Thanks for listening, and until next time.
This podcast contains general, condensed summaries of actual legal matters, statutes, and opinions for informational and educational purposes only. It is not meant to be and should not be construed as legal advice. Listeners with particular needs on specific issues should retain the services of competent counsel. For more information, please visit our website at www.williamsmullen.com or contact any member of our team.